Good afternoon, just afternoon. It's now 12 o'clock, and we are going to start our program. This is IP 102, Protecting Your IP Assets. My name is Ariana Frankel, and I'm an attorney with Schotz in the New York office, and I'm joined by my colleague David Gold, who is resident in our New Jersey office. David and I specialize in IP law, and we're going to talk to you today about protecting your IP assets once you've created them. This is the second in a three-part series, and each program is accessible on YouTube after its initial presentation. We plan about 30 minutes of presentation time, and then we'll take questions. Everybody who's logged in should be able to see at the top of their screen a little Q&A button. You can press that to submit questions during the program, and we'll pick them up once our presentation is concluded. We can break down our discussion today into three parts. What's protected in terms of IP automatically? That is, as soon as it's created, it acquires some type of intellectual property protection. Other IP is protected by the government, in some cases solely through a registration or other action taken with government assistance. Once you've acquired your IP and its form of protection, whether automatically or through a formal process like a registration, then you have to enforce it, and that's where we will talk about IP protected by you. David is going to start us off discussing what intellectual property is protected automatically.
Thank you, Ariana. Good afternoon, everybody. As Ariana just mentioned, the first thing we're going to talk about is how certain types of intellectual property are protected automatically. There's a common misconception that in order to be protected, one must register their IP with the government. While there's certainly many benefits to registering one's intellectual property with the government, which we'll discuss shortly, there are certain rights that automatically attach. These are known as common law rights, and how and when those rights attach is what we're going to discuss now. So the first type of IP we're going to talk about is trademarks. You'll see we have use it or lose it. And we hope that all of these little catchphrases will be useful to you to keep front of mind as these issues come up, and we'll get into a little deeper analysis of what these mean. So, use it or lose it. Again, we're talking about common law trademarks. It's important to understand that even if absent a federal registration, there are certain rights that will attach as long as you have a viable trademark and that trademark is in use. The test is really whether there is actual and continuous use of the trademark, emphasizing the latter, that the use has to be ongoing and not a one-time thing, or a trademark that has not been used as a trademark in some period of time. There's a number of things we look at when we're determining whether a common law trademark exists. The first would be whether the word, phrase, or design, whatever the case may be, is actually being used as a trademark. As was discussed on the last webinar, a trademark is a source identifier and must be used in such a way that the consumer associates the mark with the particular goods or services of a company or an individual, whoever the owner of the mark is. We run into this issue a lot with people who believe they have protection for basically every word, phrase, or design they use on their website or on their products, and that's just simply not the case. Another related consideration is whether the mark is or has become distinctive. This is particularly true in cases where the mark may be considered somewhat generic or descriptive, which is what we'll talk about in a second, or over time has acquired secondary meaning. The mark has acquired the meaning more than what you might think of just by looking at it. Again, connecting the mark with the goods and services behind it or associated with that trademark. Secondary meaning is less important when the mark is already itself distinctive of the goods and services. And we like to think in terms of a spectrum. At one end of the spectrum, we have what we call generic or descriptive marks. A generic mark would be the use of the word apple to sell apples. an example of a descriptive mark would honey crust to describe a pastry with a honey-based crust. Those would be the weakest and least protectable marks, while on the other side of the spectrum we have what we call arbitrary or coined trademarks. Those are the strongest marks. We think in terms of marks like Exxon or Google, or using the example we used a moment ago, Apple, but this time for computers, not for apples. Where a mark falls on the strength continuum is something we address in the early stages of any trademark or branding discussion, and something everybody should be doing when they're developing a brand. One of the greatest limitations to common law trademarks is that common law trademarks are territorial, meaning they're limited to the geographic area where the mark is actually used, and Ariana is going to touch on this in a little more detail in a moment. And along those same lines, common law trademarks often come into play when you're determining whether a proposed mark, a mark you want to use, infringes on another's unregistered mark. You know, without getting too into the weeds here, it's suffice to say that you should consider all marks, common law and registered marks, when deciding whether a mark will conflict or infringe on others. So moving on to copyrights, make it's yours. Again, there's a common misconception that registration is necessary to be afforded copyright protection. This again is incorrect. In fact, you hear many people saying, I need to get my copyright. What they're really referring to is a copyright registration, not the copyright itself. And just to touch on for a moment, a copyright, I believe, was talked about in the first webinar. Well, a copyright is actually a bundle of rights, not some sort of amorphous concept. It's, you know, the right to copy, perform, create derivative works, etc. According to the U.S. copyright law, copyright actually attaches to a creative work as soon as that work is fixed in a tangible medium of expression. So what does that mean? It means that a creative work is protected, you know, the moment pen is put to paper, the moment a photo is taken, or a work is created. Essentially, once it goes from an idea in your head to some tangible form, and remember, we talked about at the first seminar, there is no copyright protection for an idea. But again, as soon as this tangible form is put to paper, the bundle of rights kicks in. This is again different than trademarks, which, as we just discussed, have to be actually in use to be afforded protection. Moving on to trade secrets. Keep it quiet. Trade secrets are actually protected in all instances without registration, and there is no mechanism for registering a trade secret. And the most obvious rationale for this is you don't want to publicly disclose your trade secret, because then, well, it'll no longer be a secret. And you could compare that to a patent, where a patent owner actually has to file documents publicly disclosing the details of their invention. Trade secrets can be protected for an unlimited period of time, as long as certain requirements are met. First, the secret must actually be a secret, and that might seem kind of obvious, but it can't be generally known or readily accessible to the general public. Second, it must have some commercial value to the individual or organization that owns it, and that value must be derived in whole or in part from the exclusive possession of that secret information. And finally, steps must be taken to keep the information a secret. And there's various, you know, and often very highly entertaining ways that trade secrets are protected. More commonly, you have non-disclosure agreements and non-disclosure provisions in employment agreements. But again, others take much more extreme efforts to protect their trade secrets. Perhaps many of you have heard about the Coca-Cola and Kentucky Fried Chicken recipes. Coca-Cola, you know, posts these pictures of lines of this, you know, humorously large safe that it supposedly has its recipe in. And the rumor has it that only 2 people actually know the Coca-Cola recipe, and that those 2 people can't actually be in the same place at the same time. This all might be, you know, a little bit of a wives' tale, but the idea is that very few know the recipe, and Coca-Cola would therefore have very little trouble establishing that they took the necessary steps to protect their secret formula. Finally, we have personality rights. You were born with it, sort of. These rights are also commonly known as right of publicity or likeness rights. And generally speaking, these are the rights to control the use of your name or likeness in certain situations, such as to endorse products or companies. The key here is that the name or likeness is being used to someone else's commercial benefit rather than your own. There are a number of considerations concerning personality rights that go well beyond what we could cover today, such as First Amendment, free speech considerations, editorial uses, using names in the news, and other forms of fair use. And obviously, if you had any questions about the use of somebody's name or likeness, you should reach out to one of us or to an attorney just to make sure you don't get yourself in trouble. We have on several occasions been asked whether a company can use pictures of celebrities using their products that they found, on the internet or social media or in the news to promote their own products. And we get the call, hey, X celebrity is using it. What better person, what better endorsement can I have to put on my website? Well, the answer is you can't do it, absent some agreement with the person in the photograph. It's often a somewhat deflating conversation, but it doesn't mean you can't reach out and see if you can arrange for something. Like trade secrets, these rights, personality rights, are automatic and can be enforced regardless of any sort of registration, again, which doesn't exist. So we're going to move on now to what's protected by the government, and I'll hand the microphone back over to Ariana.
Thank you, David. Continuing with our tripart theme, looking first at trademarks, there are numerous benefits to registration. As you can see on our slide, registration is optional for trademarks and copyrights. We'll talk about what that means with respect to each, but highly desirable in any event. And we're going to focus our conversation on the benefits of obtaining government registration for your IP. Mechanics could take up another presentation entirely, so we'll just touch on that a little bit. There are different mechanics for going through the registration process for each of trademarks, copyrights, and patents. With trademarks, probably the biggest benefit is something that David touched on earlier. Registration provides territorial expansion. And what that means is that you can get, through a federal registration, protection in all 50 states, even if you're only operating in 2 or 3 states. And that can be very important for a foundling company, certainly, who's looking to expand, but won't be able to get there for a while. It gives you the security of knowing that your mark will be preserved for you so long as you continue your use in the couple of states that you're in. There are also some similar benefits that you get with respect to foreign rights if you have applied for a federal registration of trademarks in terms of timing and priority. So that's an additional territorial related benefit. In order to bring a claim for trademarks in federal court, the enforcement activity, you will need a registration. And there are certainly different opinions, but my view has always been that federal court is a much preferred forum for resolving disputes. Trademark registration also gives you the possibility of recovering attorney's fees. The default rule in the United States with respect to the costs of litigation, and specifically attorney's fees, is that you do not get them unless you have a contractual right or there's a specific statute that gives you that possibility. It's not guaranteed, but with trademarks and copyrights and patents, registration does bring the possibility of recovering fees. Finally, on trademarks, it's worth noting that registration can give some additional, I would say, benefits or expanded rights with respect to domain names and the ability to prevent cyber squatters, which is where someone registers a trademark or a brand name when they have no legitimate basis for using that domain and basically parks it looking to, usually to resell it to the owner. And so having a federal registration is very helpful in that regard as well. With respect to copyrights, again, you have a registration optional type of structure. And we say sort of because you can't sue anywhere without it. Whereas with trademarks, without a federal registration, you can still bring an action. With copyrights, you're not going to be able to sue for infringement if you haven't already registered the mark. There are also some very significant benefits that come with registration in the form of statutory damages and the availability of recovering set amounts under the statute rather than having to prove specific damages. That could be very significant if you have a case, say, where your website content has been copied by someone and it might be difficult for you to prove the value of that content, and certainly could be expensive. You have the ability to opt for statutory damages. The amount of those can vary, but the statutory damages structure coupled with the ability to collect attorney's fees, which in copyright cases, I'll just say very generally, is probably a lot easier to obtain as a copyright owner than, say, for trademarks or patents. It makes it more feasible for let's say, the pulper to bring a case. If you're an artist or a songwriter, you don't have significant means, you have a much more of an ability to seek redress if someone's infringing, having registered your copyright. Moving on to patents. Patents is one IP type where you only get it if you have obtained a registration. And what you do there is probably the most complicated in terms of the mechanics. It's very unusual for individuals or companies to try to obtain their own patents. You're almost always going to be working with a lawyer, although you do occasionally see the garage inventor or shop inventor that is pursuing their own patent applications. That can take a very long time, but the benefits are probably greatest in terms of what you actually get for your registration because you get a monopoly. You can apply for a patent on an invention that is a method of, say, manufacturing something or a device, but not on an abstract idea. And that's pretty much true really for all IP, is that you can protect embodiments of ideas, but not pure ideas themselves. And patents is one area of the law where that concept has been discussed at length. So in order to get any benefits from owning a patent, the monopoly, the ability to potentially recover attorney's fees, damages, you have to apply for and receive an issued patent. I should note that you can also apply for and get a design patent, which has some overlap with trade dress, which would fall within the trademark context. It's probably enough to just mention that so that you're aware that there is an area of protection under the patent laws for design. The other thing to keep in mind, which David touched upon, is that if you don't apply for a patent, you have a significant risk that you can lose your rights if you are making use of that invention in public. So if you are practicing the method under most circumstances, then you haven't applied for a patent, you can lose your rights because of the public disclosure. Patent inventions, in order to be patentable, have to be new, and the use without filing basically eliminates the novelty component. You can have applied for a patent and perhaps won't get it, and during that interim period you can have a quasi-protection in the sense that you aren't going to have a problem with having been out there using your invention, but ultimately if you don't get the patent application, then your rights won't advance. The other thing that David touched on, which is worth discussing here, is with respect to keeping your idea, your invention, secret until you get your patent, or potentially indefinitely. When you have an invention that you are keeping secret and therefore getting a trade secret, you would not be able to go ahead with a patent because ultimately your patent has to your application will be published. But sometimes you're better off not pursuing a patent registration and simply maintaining your invention as a trade secret. The main benefit to that is that it's unlimited duration. With a patent registration, it's a limited term. There's some variation, but you're basically looking at about 2 decades of protection. Whereas with a trade secret, like David mentioned, so long as you adhere to the requirements, most importantly that you're keeping it secret, your protection can go on indefinitely. So that's definitely something to consider when you're making the decision about whether to go ahead with patent filing. And just a note on the mechanics. With all of these registration mechanisms, you can pursue them on your own. We see that most in the context of trademarks, although a lot of times we see clients that come in after they've done their own work initially and then realize that they need help once the process is in motion. There are also services that will do filings for you. That seems, in my view, to be most successful in the context of trademarks, where the issues are of medium complexity in most cases. Copyrights, oftentimes what we'll do is we will teach a client how to go through the steps to do the registrations themselves, because it is pretty straightforward and can be done online very inexpensively. Patents, generally speaking, you're going to want to consult with an attorney for a whole host of reasons, including the cost of filing fees. That in and of itself makes it worth speaking to an attorney before you go ahead with the filing. And just a quick note on trade secrets before we move on to the next topic. There's no registration mechanism for trade secrets, but there is statutory protection, which does help when you're pursuing claims. There has been state law protection for a long time, but more recently there is a federal act, the Defend Trade Secrets Act, that was enacted and is now provides an additional layer of protection for you to go into court and seek redress if someone has stolen your trade secret. And finally, perhaps one of the most common themes in the registrations is that the instance of having a registration or even an application pending can serve to discourage infringement, both because you can notify the public through the notices that David's about to talk about that you have either something issued or pending, and a lot of times that will discourage people or companies that might otherwise have wanted to borrow your ideas and inventions. So, and with that, I'm going to turn over to David again to talk about how you protect your IP once you've obtained it, either automatically or through government registration.
Thanks. So, yeah, I mean, you now have your IP, great, whether it be common law or a registration. You have your C or your TM or your R, which we'll talk about in a minute. But your IP is not some sort of amorphous concept that's now going to operate on its own. You know, there's not some sort of, copyright police force going around checking to see if everything is above board. As funny as it might sound to have some sort of police force with a big C on their cape, it just doesn't exist. And really, we can't emphasize this enough. The first line of defense of your IP is you. You need to monitor the marketplace to identify potentially or actually unauthorized use of your intellectual property. And it's really surprising how few people and companies and IP owners actually monitor what's happening with their IP, not only in the United States, but all over the world. And monitoring can be done at various levels of thoroughness, such as simple internet searches and alerts. I know there's various search providers that you can just put in certain terms, and when they appear on the internet, you'll get a notice about it. There's page watching services, and there's third-party services that could be essentially as comprehensive as you want them to be. Those can be somewhat more expensive, but certainly if you're a business with valuable IP, it might be a worthy investment to have a company looking and monitoring the marketplace to see what's going on. This is important not only for the obvious reasons, but, for two less obvious reasons. First, with regard to trademarks, trademarks have to be monitored and they have to be policed. And if you don't, you may lose some of those valuable benefits that Ariana was just speaking about. Also, you have your protection, but if you don't act on your protection, you could lose your rights to your claims, your infringement claims for what we call statute of limitations issues. If you sit on your rights too long, there is a possibility that your claim will no longer be valid when you decide to go ahead and bring that claim. Monitoring the marketplace is particularly important in connection with ISPs, or Internet Service Providers. You think YouTube as a good example. And very generally speaking, an ISP will not take down or take action against infringers unless they're put on notice of infringing activities. Perhaps more importantly, an ISP is not going to be held liable for infringing activity unless they know of the infringing activity. We're not going to get into it today, but this is a little different than strict liability, where sort of an innocent infringer may still be held liable whether they know about it or not. Here, if an ISP does not know about the infringing activity of the millions of videos on their website, they are not going to be held liable for that activity. Once ISPs are made aware of their infringing activities or a claim of an infringing activity, the law, which is the Digital Millennium Copyright Act, requires that certain steps be taken, such as temporarily removing the infringing work and notifying the infringing user, who then is given an opportunity to respond. Many ISP terms of use will and should include Digital Millennium Copyright Act forms and other mechanisms to streamline this process. And courts have generally blessed this approach. For example, if you look at the recent line of YouTube and Viacom cases, the courts held that absent notice of infringing activity to YouTube, the burden of identifying the infringing material remained with the copyright owner, not the ISP, in that case YouTube. A lot of people have problems with this approach, but whether you agree with it or not, that's the law for the moment. So what are some other things an IP owner can do to discourage others from using their IP without authorization? Well, the first step is to make sure people are aware of your ownership rights. And the easiest way to do that is through notice. Most people are aware of the various forms of notice, either the C in the circle, the TM, the R in the circle, patent pending, or the actual patent number, but don't necessarily understand why that notice is important, or in some cases required. Again, given our time limitations today, we're not going to be able to dig in too deep regarding the ins and outs of notice, but wanted to touch on a couple of points. First point, notice is not always required to recover. For example, contrary to popular belief, there is no longer a requirement that copyright notice, the C in the circle, be placed on a creative work. That said, notice is highly recommended to put the world on notice of your copyright ownership, not only to prevent unauthorized use, but try to spin it slightly more positively so that people can contact you if they see something they like, if they see a photo online that you took or that you own and they want to license it. There's a big problem that Congress has actually been looking at called the orphan works problem, and it's somewhat what it sounds like. People see these works online or somewhere else, and they cannot identify or locate the copyright owner. I mean, the Copyright Office does not make it easy to search, and given some credit, it's not always, what are you going to put in a picture of a person with nice, it's not easy to describe in order to hit and then find the copyright owner. And that's assuming that on the Copyright Office database, the information was actually correct and updated, et cetera. So, there is a possibility that somebody will want to use your work or want to license your work, and if your name is printed on it with a copyright notice or the company's name is on it, it'll make it a lot easier for them to locate you. In other cases, notice is required, but again, we're not going to get into the details really more than just to say you should, if you have any questions about notices, particularly in terms of patents, please reach out to us and we can run through it quickly with you. We also wanted to briefly mention some misuses of copyright notice. For example, a trademark owner can only use the R when the trademark is actually registered with the Trademark Office. Absent a registration, a TM can be used, but really only indicates some claim to trademark rights, not necessarily the validity of that claim or otherwise. So, a fun exercise to us copyright and trademark nerds is to go around the supermarket and see what has TMs and what has Rs and try to figure out why a registration may not have been attempted or actually registered. Oftentimes we also see people sort of flippantly putting patent pending on things. Just because you think at some point you're going to get a patent does not mean your patent is pending. A patent pending notice is not proper unless a patent application is actually underway, and there are potentially serious consequences if these notices, in all respects, are misused. So people just need to be very careful. And again, if you have any questions, we can answer them. Now we're going to move on to a couple more things you can do to help protect your IP, and for that, I'll pass it back over to Ariana.
Thanks, David. So David touched on the last point here on our slide already. I'll address that just briefly. The remaining two topics, letter campaigns and what we have up here as the big stick, are really your enforcement mechanisms. You've given notice, you've watched to see what's going on and identify infringers, and then the question is, what do you do next? Or perhaps someone has notified you of an infringement, and that often is how you find out about things. Letter campaigns, also referred to as cease and desist letters, a lot of times can encourage a voluntary cessation of infringement, which is great. It helps you to avoid what is often a significant expense of litigation, simply by writing someone and telling them that you think they're infringing and they should stop. With that in mind, you can also monetize your IP through letter campaigns. So one of the more important and less intuitive, perhaps, aspects of letter writing campaigns is how to approach it. Are you sending a polite letter that's designed to send a nice message that no one will get too mad at you for? That might be very important if you're in a high-profile position or the recipient of your letter is. Maybe you don't want to see a nasty letter from you on the Internet, which can happen, or in some other public forum, which can sort of come back to bite you in different ways. In addition, your cease and desist letter, depending on how it's written, could trigger a lawsuit against you. And if you're not ready for that, or you wanted to be the plaintiff and pick where you were going to sue, there are strategic considerations that you want to be keeping in mind before just shooting out a cease and desist letter. That said, in general, your formula for a cease and desist letter is you are alerting someone else to your rights, you're telling them what they're doing that's wrong, and then you're asking them to stop. And perhaps you're asking them for money. Licensing letters are more likely to be suggestions that certain intellectual property you own is valuable to the recipient, and they might like to talk to you about how they can license and pay you for the use of their IP. Sometimes those types of letters are really just sort of the first step in what will ultimately be a lawsuit. Other times they really are just invitations. If your letters don't work, then the next step, which is probably no surprise to you now, is bringing a lawsuit. And generally speaking, for most IP, certainly of the registered type, you either can or have to bring your claim in federal court. You can bring some claims in state court, depending on the type of IP and protection that you have. The main reason to pursue a lawsuit is if you can't get what you needed through some other less expensive and time-consuming mechanism, or if you have a much larger enforcement program going on, but perhaps you're not listening to this presentation today if you are operating at that level of IP enforcement. So I think for most people, litigation is something that they're going to want to avoid, and you use as only a last recourse type of activity. In addition to claims that you can bring yourself, there is the ability to get the government involved, either through criminal proceedings or customs and border type of enforcement. That particularly comes up in the context of counterfeit goods and prevention of counterfeit imports. So that's something that you can pursue depending on the type of IP issue that you're having. And then finally, I would note with respect to escalating above the letters with domain name disputes, it's good to be aware that there are additional forums that are akin to arbitration organizations where you can obtain generally very fast relief in the order of months, but it will be limited. So if someone is using your mark in a domain improperly and it meets the other requirements of that type of enforcement activity in terms of your ability to get them to stop, you may want to opt for one of these expedited mechanisms. Finally, David did address generally the idea of why it's important to monitor and talked about the delays and mentioned the statute of limitations. All claims have statutes of limitations. It's not just IP related. And what that basically means, if you're not familiar with it, is that there are time limits on how long you can wait after a claim arises. So for instance, after the first time somebody infringes on your, say, trademark or your copyright, that you can bring your case. In some instances, the time that is accruing will continue anew, depending on if, say, there's a new instance of infringement. There's variations in the law with respect to different types of IP about how that works. But it is the main thing to note and take away from today is that you cannot sit around and do nothing without running the risk of losing your rights. And David did mention the concept of defenses that are based on fairness. That is, if you take too long after an infringement to do anything about it, and particularly where you've been in communication with the infringer so that the infringer then develops a reasonable belief that you are not going to take action, the court may view that as a situation where you have waived your right because the infringer basically started acting in reliance on your inaction. So again, these are just important to keep in mind as you are out there exercising your IP rights. So that concludes the formal presentation part of our program today. We are going to switch gears and take your questions now, if anyone has any, or if you'd like to speak with either David or I after this program, you can feel free to reach out to us. Our contact information is in the slide in front of you, and we'd be happy talk to you anytime.
So we do have one question, and it is, how long does my patent provide a monopoly?
It depends on the type of patent that you have obtained, but in general, for most of what people think of when they think of patents, you're looking at just under 20 years. It's 20 years from the date of filing or 17 years from issuance is how it works. And there can be some adjustments in unusual circumstances, but you're generally looking at about 2 decades.
All right, so not seeing any other questions. I think we're going to wrap things up. We do want to remind you all that we have our third of our 3-part series coming up, IP risk prevention, staying out of court and out of trouble. And what we're going to do there is sort of flip things around a bit and move away from, considerations of one's own IP and start looking at issues, among other things, start looking at issues concerning the use of other people's IP, when it's permitted, when it's not, and take things from a little more of a defensive or perhaps just more intelligent perspective. So with that, we thank you all for joining us today, and we look forward to seeing you next time.
Thank you. Have a great day.